Welcome to the next lecture in the Understanding Crypto series by Thomas Plunkett. This is a crypto law lecture on When Howey Met Gary. These slides were created by myself. They're not investment advice or legal advice. They're only materials for educational purposes, and mentions of particular blockchain projects should not be construed in as an endorsement of those projects. So this video is really diving into some of the details that were shared by William Hinman of the SEC in a speech he gave in 2018. His speech was intended to bring clarity to cryptocurrency regulation. And the question he asked in that speech was, can a digital asset that was originally offered in a securities offering ever be later sold in a manner that does not constitute an offering of a security? And at the outset of the speech, he said, well, if the digital asset represents a set of rights to give the holders of financial interest in enterprise, then the answer is likely no. But on the other hand, he suggested that if there's no longer any central enterprise being invested in, or where the digital asset is sold only to be used to purchase a good or service like a currency, then there's a qualified yes here. And the rest of his speech focused on this qualified yes. And so you can take a look at his speech at SEC.gov at the link I show here on When Howey Met Gary. So let's talk about what we're diving into. So first off, let's talk about the Howey case, SEC versus Howey. So the Howey case is a Supreme Court case that gave rise to what's known as the Howey investment contract test, where an investment of money in a common enterprise with expectation of profits derived from the efforts of others is essentially a security that can be regulated under the securities laws. So the facts in the Howey case were that a hotel operator sold interest in a citrus grove to its guests and claimed it was selling real estate, not securities. While the transaction was recorded as a real estate sale, it also included a service contract to cultivate and harvest the oranges. The purchases could have arranged to service the grove themselves, but in fact, most were passive, relying on the efforts of Howey and the Hills Service for a return on their investment. So this is essentially a security interest, even though it's recorded as real estate sale. And so what this case stands for is that the form or the paperwork doesn't determine whether something's a security. Instead, the question is this an investment of money in a common enterprise with expectation of profits derived from the efforts of others? In that case, it's a security. So how do we apply this to Bitcoin? So Howey said when he looks at Bitcoin, he doesn't see a central third party like Howey, whose efforts are a key determined factor in the enterprise. The network, Satoshi Nakamoto famously walked away and left Bitcoin shortly after he founded it. And instead, the network on which Bitcoin functions is operational and appears to have been decentralized for some time, perhaps from inception. Applying the disclosure regime of the federal securities laws to the offer and resale of Bitcoin would seem to add little value. You could say that Satoshi was pretty central to Bitcoin for the first year or so, but after that year, Bitcoin has been completely decentralized. So let's take a look at how William Hinman applied security analysis to Ethereum. And putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, again, this was written in 2018, the Ethereum network and its decentralized structure, current offers and sales of Ether are not securities transactions. And as with Bitcoin, applying the disclosure regime of the federal securities laws to current transactions in Ether would seem to add little value. So this is a really important point because he says right away that there was fundraising that accompanied the creation of Ether back in 2015. 3 years before 2018 when he's writing this, but he's saying 3 years later, current offers and sales of Ether are not securities transactions. So those transactions back in 2015 might have been securities transactions, but the current ones in 2018 at the time this was written were not securities transactions. That's a really important point, that you could go from raising funds as a security into a decentralized currency. So again, this was from the When Howey Met Gary speech that you can take a look at on SEC, and hopefully the SEC will continue to clarify the rules that cryptocurrency startups can follow to avoid violating securities regulations. We'll take a quick look at that article on the SEC website here. So let me go over to that. Here we have the article. It's digital asset transactions when Howey Met Gary. Again, he gave this speech in San Francisco in 2018. And again, he kind of lays it out the way I said. He starts off with giving the background of Howey, what he thinks about crypto and ICOs in general, and then closing with his discussion about Bitcoin and Ethereum. And he points out that, again, his analysis of whether something is a security is not static, and it's not based on the form. Instead, it's based on what's actually going on with the facts. And then he lays out some factors to consider based on the factors in the Howey case and how it can be applied to ICO tokens and other forms of cryptocurrency. So going back to the slides again, I'd like to thank everyone for listening to this presentation on When Howey Met Gary, a part of the Understanding Crypto series by Thomas Plunkett. If you have any questions or comments, feel free to reach out. Happy to hear your feedback on this presentation.